If you are contributing to your child's or grandchild's registered education savings plan, do you have a plan for what happens to the money should you face a serious health issue? Who would you leave in charge of making those decisions in case of your incapacity or even your death? Joining us now is Nicole Ewing, principal of the Wealth Planning Office at TD Wealth, who says this is something that's often overlooked in estate planning. Nicole, it's such a great thing to bring up because, you know, every grandparent is probably like leaning in a little bit right now to understand what they should be doing. But before we get into the issue, let's just back up a little bit so we're all on the same page in terms of information. Normally, with an RESP, this is something that a parent can set up, or a grandparent, or even somebody else if they want, to fund someone's education, correct?
That's right. And there are some restrictions around who can set up depending on what type of a plan, whether it's an individual plan, a family plan, or a group plan. There's some restrictions around who can be the subscriber and who can be the beneficiaries in those situations. But ultimately, the goal is to have this tax-efficient way of saving for a child's education. So you're able to contribute up to $50,000 per beneficiary, and then there are annual grants that you are able to receive from the government if you're qualifying for those, and there's some bonds as well. And ultimately, the funds within the RESP are growing in a tax-deferred environment, ultimately to be able to be withdrawn tax-free for the benefit of, or the contributions tax-free, and then the educational component able to be taxed in the hands of the beneficiary, presumably at their lower rate, ultimately when they're using that for their post-secondary education.
Okay. And you've thrown some terms around, and I want to make sure we're all on the same page too with that. So subscriber, the one who actually is the one who's been giving the money to the RESP. And then well, maybe, actually, instead of me defining them, how about you define them, just so we're all on the same page?
Right, so the subscriber is the individual or joint individuals, depending, who have created, who will be contributing to the RESP. The promoter is the person with whom you contract, so generally your financial institution that you're contracting with. And then your beneficiary, which is a little bit different than we think of beneficiaries for other registered plans. The beneficiary is the person for whom they will receive the educational component, the funds that they can use for their education. It's not the same as a beneficiary for an RRSP or a RIF, where that's the individual who's going to receive the amount upon death. And this is where we want to sort of step back and think that these registered plans are unique in that they have, you can name a successor subscriber within your will to be able to take over this account for the benefit of the beneficiaries. But if they're different in that the subscriber is the one who's actually able to collapse these plans at any time and receive those funds back to themselves. So that might be the person that you name can actually pull these funds back and use them for themselves and not use them for educational purposes. There are tax consequences of doing that. And so many lawyers now, when they are creating a will for an individual, if they are contributing to an RESP, if they're a subscriber to that RESP, they're giving them advice around perhaps naming their spouse as a joint subscriber, if they're able to do that based on the contract terms of the plan, and then having within the document themselves, within that will, instructions about what is to happen to this RESP, how it's supposed to be funded. But what's not as common, what we don't see as often, is for if somebody has incapacity and they have an attorney for property under a power of attorney acting for them, we don't often see instructions about what to think about and how to treat these plans in that instance, and it can really lead to some confusion and unfortunate results if it's not planned for.
Yeah, when you think about it, and I mean, just, you know, taking some of the examples you're giving, if you're a grandparent and you intend for you to, you know, you want to fund your grandchild's education, maybe post-secondary education, if something happens to you, one would think that the intent is that you wanted to continue doing that, but unless it's expressly stated, you know, somebody else may change and use that money for different purposes. So to that end, let me ask you, what are the ways in which people should be thinking about putting something in place that allows for that to continue?
Okay, so if you're a grandparent who is giving money to the parent of the child to contribute to an RESP, which is very common, so you're not the subscriber yourself, but you make this contribution every year, through the parent, you'll want to ensure that your power of attorney document actually allows for your attorney to continue to make those gifts, because there are some restrictions around whether or not that attorney is able to make gifts on your behalf and is able to use funds for the benefit of somebody other than you. So if it's simply a gift you're making every year, make sure that your power of attorney document specifies that you want that to continue. But you'll also want, if you are the subscriber for an RESP, you'll want the power of attorney to contemplate things like, or to define what was the intent of setting this up. Do you intend it to go to the beneficiaries? Now, we can assume that's the case, but it's well worth defining that, putting that in writing. We want to think about whether or not you want the contributions to continue. So if you find yourself in a state where you do not have capacity, and do you want those funds to be used for your care and for your benefit, or do you want to give your attorney for property authorization to continue making contributions to the RESP? If so, how frequently and how much do you want them to do? Would you like them to have the authority to add an additional beneficiary if the plan allows for that, if it's a family plan, for example, to benefit a family member that might come after you have incapacity? And really think about under what circumstances you want the attorney for property to be able to take funds out. So whether it's a refund of contributions, whether you want them to benefit yourself or benefit the beneficiary, that will depend on where things are taxed, perhaps. The accumulation income payments, so those are the income that has been earned within the plan. How do you want those to be dealt with? And similarly, whether you want to allocate things as an educational assistance payment. So defining how you want the attorney to treat those proceeds, whether you want them to use them for your benefit, if you want the beneficiary to receive these funds, do you want those contributions to continue? And ultimately, do you want them to make any decisions, or how do you want them to make decisions when it comes to any tax consequences or minimizing tax consequences to various parties? So again, sitting down, making sure that the person who's drafting your will for you really understands the circumstances at play, and then can define what is necessary within your own documents to get the result that you're looking for.
Yeah, we always land in the same place, know what you want, talk with your planner, talk with your advisor, figure it out, and then you can execute the plan to make that happen, right?
Absolutely, every time.
All right, Nicole, thanks so much.
Oh, my pleasure, Kim.